Let's talk about improper relationships between an educator and a student in Texas. Improper relationship between an educator and a student is a second-degree felony in Texas. That means it carries a punishment range of 2 to 20 years in prison. It's a serious offense, and yet there are things about this offense that are unique and probably not intuitive. First, an improper relationship between an educator and a student is broader than just applying to teachers. In fact, many employees that work for a school can qualify as a potential defendant under the statute. Counselors or other professionals, even uncertified professionals who work at the school and are therefore around students. It applies to students that are in junior high and high school in Texas. An improper relationship charge is an accusation that a person of a particular type, that's a teacher or an otherwise qualified employee of a school, had an intimate relationship, a physical, sexual relationship with a student. It also includes improper materials that are sent by text message. So things that would otherwise qualify as online solicitation of a minor can become the substance of an improper relationship charge. Here's something that's not intuitive. There is no age threshold or requirement for this charge to be brought. In other words, any student of any age that's in junior high or high school, whether they're 18, 19, however old they are, before they end high school, if they enter into a relationship with a teacher or otherwise qualified employee of a school, that will become the substance of an improper relationship charge. An improper relationship charge can be brought against both public school employees as well as private school employees in Texas. A second thing that's not intuitive about improper relationship charges is that it does not carry a registration as a sex offender requirement in Texas. And that's because this offense can apply to cases where the student is already 17. And typically when you see registration as a requirement in Texas, it applies to offenses exclusively intended on victims or alleged victims who are 17 or under. A third thing that is not intuitive about an improper relationship charge is the fact that the statute of limitations is only 3 years. For most sexual offenses, you don't see any type of statute of limitation in Texas. In other words, if there's an accusation that a person was touched sexually before they turn 17, that charge can be brought at any point in the future. Unlike that offense, however, and unlike most sexual offenses, an improper relationship charge must be brought within 3 years of the alleged conduct. Understand that improper relationship charges are tough cases to face. Inevitably, you'll lose your job. You will almost certainly lose your teaching certificate. It will be difficult for you to find employment while your case is pending. Everything is on the line, so although there are some things that this case does not have, like the registration requirement, there are so many collateral consequences of just being charged with this that it's important to find the right counsel at the right time, which is as soon as an allegation is made. We have successfully defended these types of allegations, as tough as they may be. So if you find yourself in the crosshairs of an investigator, an investigation, or have actually been arrested for this charge, contact us immediately. We made this video in response to a question we received on this channel. If you have a question about criminal law in Texas or any federal criminal law, drop a comment below and we look forward to answering those questions in a future video.